Receiving inherited property can bring a mix of emotions, especially when it is valuable farmland. You might be wondering about the next steps and if you have to navigate a complicated legal process to call it truly yours. The direct answer is that whether you need to probate inherited farm property depends on several key factors, primarily how the property was owned and the specific laws of the state where the farmland is located. Probate is not always necessary for all inherited assets, including real estate. The necessity for probate largely hinges on how the property was legally structured before the previous owner passed away. If the farmland was owned solely by the deceased without any co-owners, a will, or a trust, then probate is almost certainly required to transfer ownership. However, if the property was held in joint tenancy with rights of survivorship, or tenancy by the entirety, the ownership automatically transfers to the surviving owner, often bypassing probate entirely. Similarly, property held in a living trust would typically transfer to the designated beneficiaries outside of the probate court system. State laws also play a significant role. Some states offer simplified probate procedures for smaller estates, which might include certain farmland properties under a specific value threshold. Additionally, some states allow for transfer on death deeds, sometimes called ladybird deeds, which automatically transfer property to a named beneficiary upon the owner's death without the need for probate. Understanding these state-specific nuances is crucial. To determine if probate is needed for your inherited farmland, start by gathering all relevant documents. This includes the property deed, any will or trust documents left by the deceased, and information about how the property was titled. Next, consult with an estate planning attorney who specializes in property law, especially one familiar with the laws in the state where the farm is located. They can help you understand the specific requirements and explore options for a smooth transfer of ownership. One important detail to consider is if the inherited farmland is located in a different state than where the deceased person primarily resided. In such cases, even if probate is handled in the primary state, a separate process called ancillary probate might be required in the state where the farm property sits. This additional step ensures the property title can be legally transferred according to that state's real estate laws, which can add complexity if not addressed properly. Ultimately, understanding the type of property ownership and the applicable state laws is key to efficiently managing inherited farmland. Taking proactive steps, like reviewing existing documents and seeking professional guidance, ensures that you can avoid potential legal delays and preserve the value and legacy of the farm for future generations, allowing you to focus on its potential.